Hey guys, now that they have a suspect in custody in Idaho for the slayings of the 4 college students, I thought it would be interesting to look at some of the legal procedure in Idaho, some of the things that will happen before trial, during trial, that might be unusual or not apparent to you off the top of your head. As you know, every state can have its own rules, at least as long as they comport with the Constitution of the United States, then they can pretty much do everything they want. So as you travel around the country, there's always some surprises as you go from state to state. Idaho's not an exception to that. Here's a tip-off for an example. They don't have the insanity defense in Idaho. You'd think that would be required everywhere, but they don't. And we'll get into that a little bit when we get into the what kind of defenses he might have phase. So before the trial, an interesting thing to know is they don't have bail there for capital offenses. You are not entitled to it. What it basically says is all persons are bailable except for capital offenses where proof is evident or the presumption great. And that's kind of a term of art. You probably remember that in the defense attorney's statement in the Indiana case, the Delphi murders, where those words came up. See that in a lot of states where there's no bail available for serious offenses like capital offenses, that due to the type of the offense and what the state has on you, you're not entitled to bail. And that you can challenge that, of course, but that's the standard it would be challenged under. It's not as high, perhaps, as it sounds, at least as interpreted by courts from what I've seen. You can't have excessive bail, but when there's a violent crime like this, you can actually have no bail. That's in the Idaho Constitution, Article 1, Section 6, and Code 19-2903. Another thing to know is that people are waiting to see the probable cause affidavit released. Why they arrest this guy? What do they got on him? And as you probably know, not everything has to be in the probable cause affidavit. What you're trying to achieve with that is an arrest, and to demonstrate to the court that you have substantial evidence that supports an arrest of this person. And that evidence can be in the form of, in whole or in part, just hearsay. It's not courtroom testimony. It's for a probable cause. So they may not have all the evidence they have in there, or they may have evidence in a format that it wouldn't be allowed in courtroom testimony. That's okay for a probable cause affidavit. So it would certainly be enlightening to hear what they have on him, at least what they told the judge to get this arrest warrant. But it may be the case that they have other evidence or more evidence developing. And of course, it can be the case that the defense has a story to tell too. Now, when you're in court, there are a few things I think that could be interesting to know. You've probably seen a lot of these stories coming out of people who know this guy, Kohberger. And the police have said, hey, tell us about him. If you know him at all, tell us that. And of course, they want to flesh out their own understanding of this guy, their own picture of this guy. And that could be things that look bad for him or look good for him, or things that actually have to do with the case. We don't know yet. But a lot of stories out there about how he drinks a lot of coffee because after the crime, and he stays up late at night. He has crazy eyes. I knew he was going to do it. I can't believe he did it. He's mean to women. He was insulting to women at bars, and he's a creepy guy. And those are interesting to know about the guy. But some people have said, well, they shouldn't say that because it could taint their evidence and they may not be able to go to court with it. Well, you generally can't bring a parade of people into a courtroom to talk about somebody stayed up late, or they have crazy eyes, or they were mean to other people. And in fact, Idaho Rule of Evidence 404, which is pretty typical of evidence rules, says you cannot use evidence of character or trait to prove the person acted in accordance with the character or trait. You can't use evidence of a crime as character evidence to show that the person acted in accord with that character. So you can't bring witnesses in there and go, well, he was a creepy dude, so he probably was the guy who did this, right? He was a creepy guy. That's not going to fly. You can use evidence to impeach someone, to show they're a liar or whatever. If he were to decide to testify on his own behalf, if there were other crimes, or people could show he was a liar, then you might be able to impeach him that way. But you can't just bring a string of people in to talk about he's a bad guy as evidence that he's a bad guy, so he probably did this crime. If you want anyone to talk about how he was, you need to have some other reason for that. Now, sometimes you can use prior crimes to show a certain pattern or way that the person's doing the crime that's very distinctive. Idaho says you can also use it to show intent or motive or plan, as long as the DA gives written notice. So there are possible ways to use other crimes, but I don't think he was convicted of anything that's going to matter in this case, maybe nothing at all. Discovery material. Who gets to see what? So Brady material is automatically turned over under Idaho rules. The DA is required to do that. That's also required by the Supreme Court. And that means if they have evidence that's exculpatory, that would show that the defendant shouldn't be found guilty, they need to turn that over to the defendant, material evidence. And that's kind of up to their judgment, right? Because you don't know if you're not looking at the file, but that's the rule that they have to live under. Other evidence needs to come by written request by the defense. That's Rule 16b. That's kind of a normal discovery procedure that lawyers are used to seeing. It's not an open file scenario. I've seen that kind of comment on Reddit in some cases where it's like, oh, they have to show them everything they got. It's not a have-to situation in most cases. Most cases, the defense has to put some effort into getting the information, which they normally will do. Another interesting statute in Idaho is the alibi defense. Under 19.519, the defendant, upon request by the state, and you can bet they'll request it, must give written notice to the state if he intends to offer the defense of alibi. And if you have an alibi, you definitely want to offer that defense. That's a great defense. If the murder occurred at point A and you can show you were at point B, then you couldn't have probably done the point A crime. So you definitely want that if you have it. You must tell the state in writing the place or places that you say you were at the time the crime was committed and any witnesses and their addresses that you intend to call to support that. Then the state has an obligation to tell the defendant what witnesses we have that put you over here at point A where the crime occurred and not point B. And also, if you say you're at point B, if we have witnesses who can rebut your witnesses that you weren't there or that your witnesses are liars and things, we have to tell you that too. So that's interesting because alibi is an important defense, can obviously be a completely effective defense, and it has to be revealed in writing to the state as long as the state requested ahead of time. So final one I'll talk about is insanity defense. Under a general conception, which I agree with, if you walk into a house and stab 4 people to death who've done nothing to you, you're crazy. You are crazy. That does not mean that you're legally insane. The legal insanity test, generally the McNaughton test for most places around the country, is you didn't know what you were doing because of a mental disease or defect, or you couldn't control your actions, or you didn't know right from wrong. At that time, because of the mental disease that you had, this insanity that you had, you didn't know what you were doing was wrong. You lacked the capacity to know that. Well, Idaho does not have that defense. They do not have the defense that you can bring in psychologists to say, or psychiatrists or experts or whatever to say, this guy didn't know what he was doing was right or wrong because of the voices or whatever was going on in his head. They got rid of that a long time ago. And the Department of Justice had given an opinion saying, hey, we think that the Supreme Court is going to overturn this. There are only a few states like that, but the Supreme Court did not do that. In Kaler versus Kansas has a similar statute to Idaho. The Supreme Court said that we don't have just one single way to consider insanity or mental disease when we're looking at crimes. There's the traditional McNaughton way, but the way that Kansas does it, and therefore also the way that Idaho does it, is also acceptable. So Idaho says that if you think you're bonkers or whatever, that's something you can raise at the time of sentencing. And the judge can order that you get treatment, can consider that for the type of sentence you get and things like that, but it doesn't operate to a defense to the criminal liability that you have. It only, your mental capacity or whatever, can only help you at the crime stage if you can bring in an expert to show that you didn't have the intent. Maybe there was something gone bonkers in your head that you just didn't know what you were doing at all. Not a question of you knew it, but you didn't know it was wrong. That's the normal insanity defense, but you didn't know what you were doing at all, maybe. Or you didn't have the ability to understand the thing you were doing was going to harm somebody. Now, if you're stabbing somebody with a knife and you do that to 4 people, it's really, everybody knows how a knife works. And also, if you stab people with it, they're going to die. So I don't think that there's going to be any kind of real mental capacity defense here. And the idea that, well, I didn't know it was wrong or whatever, that's not going to come up here either. Now, I haven't seen anything about this guy to say that he was under any kind of treatment for mental illness or whatever. But the idea that the first, I'm sure, blush would be, oh my God, he could never do that because he was a high-level criminology student, so he couldn't plead insanity defense. That's wrong. We had a significant case in North Carolina a long time ago, basically contemporary with me, where there was a law student in Chapel Hill who went down the street shooting people, and he was tried for that, and he was found not guilty by reason of insanity. Now, he was a successful undergraduate student, had graduated, gotten into UNC Law School. I almost said a nice law school, and I remember it was UNC. It is a nice law school. Got into it and was attending classes there. I knew people that knew him, and this guy's very bright, and he shot people. He knew how the rifle worked. He had trained with it, and the jury said he's not guilty by reason of insanity. So there was no question that he, they didn't say, well, he didn't know he was shooting people with a rifle, but they did say, his defense team, that he lacked the capacity at the time it occurred to know right from wrong. And the state certainly contended against that, but the jury agreed with that. So here's a person who was highly intelligent was receiving training in the law, already had an undergraduate degree, and was found not criminally liable. Now, he was put, of course, into a secure mental institution, but the point is he was able to invoke the insanity defense successfully. So education level doesn't necessarily mean that you can't have at that moment the inability to know right from wrong. And this person in North Carolina certainly did have a serious mental condition. I don't think that anyone who looked at the case could say that he did not. Whether he knew right from wrong or not was the issue, of course. And you don't have to have education of any level to know that if you're shooting people or going into someone's house and stabbing them to death, that that's wrong. And whether you're at a graduate level or undergraduate, or you never went to school at all, you're going to know that. You would have to show some kind of mental condition to show that I lost the ability to know it at that time. But Idaho does not allow you to do that. You'd have to show that I didn't know that stabbing people was going to hurt them. I thought it was a hairbrush or something like that. Maybe that would help you. But I don't think that kind of thing is going to come up in this case. But I thought I would mention it because insanity defense can be raised as an affirmative defense in most states, but it cannot in Idaho. It can only be used to rebut an element of the crime for your mental intent of the crime. So very different than most states. A super based situation there. Because, of course, at the end of this, you can use it for purposes of sentencing to show why this person is not as culpable as someone else. But once you're convicted of first-degree murder in Idaho, you are potentially liable for the death penalty to receive it, although it's, of course, highly unlikely you'd ever be executed in that state for the reasons I stated in my last video. So these are some things that I just happened across when I looked at Idaho law and procedure, when I was wondering how this case is going to go. I don't think there's anything fact-wise that's going to be extraordinary about this case other than the crime itself. This guy, the things about him that'll be bonkers that comes out, assuming he's the guy that did it, that will be shocking and terrible. The crime itself is awful, but legally speaking, I think it is fairly straightforward. They're just going to need to show he was there, and therefore also he's the guy who did it. And if the defense can't rebut the state's evidence, if the state can show it beyond a reasonable doubt, then he's going to go to jail forever, likely, and probably not be executed. Who knows about that? But we'll see as the facts further come out. If you have any questions on the legal side, though, because your speculation on facts is the same as mine or whatever, but if you have a question about the law or the procedure and you want me to look it up for you as we're observers of this case, then I'll try and do it. Thanks. Bye.